Hello, everybody. It is Arty of Arty's Corporate Fiction. How are you guys doing? Um, Welcome. We're going to take a look at a case that I've been wanting to take a look at, but I keep forgetting. Everybody else has been telling me to kind of go over as well, which is the case of Sarah Boone, the 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 suitcase stuffer. I don't know if she's already got a nickname for her thing, but it's one of those oddball ones. What's funny for me is that I could have sworn I first heard about her from Donut Operator. It was one of his Leo recaps from like 4 years ago that she mentioned about this woman who stuffed her boyfriend in a suitcase. It's wild. So she has had a very contentious case history. I was already aware that she's gone through like either 8 or 9 attorneys, and now she's being forced to represent herself. But we're gonna go through this very short 6-7 minute recap of the whole case, and then we're gonna go through some of the hearings recaps as well to give us up to speed on what's going on with her, so that we're up to date on everything. But yeah, I've heard from they have been saying because I also wanted to take a look at her interrogation, because people said that she really acts like she's smarter than everybody else in that interview, but we might not have time to do it. So this is a very short true crime recaps. So very short 6 minute 40-second recap, and then we're gonna go straight to some of the other ones. All right, let's go.
See some pretty crazy stories about the fabled Florida man. Stuff like alligator-assisted armed robbery. Yes, no, true story. Some guy threw an alligator through the drive-through window of a Wendy's in Florida. A live alligator. I mean, what even is that? And much like Florida man, Florida woman should not be underestimated, especially if she thinks you've wronged her. Hey, I'm Amy. Thanks for watching True Crime Recaps. So the first sign of trouble is this 911 call from Sarah Boone. It comes in around 1 in the afternoon on February 24th, 2020.
My boyfriend is dead.
All right, great. Now tell me exactly what happened there.
My boyfriend and I were playing last night, and I put him in his case and we were playing, like kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase, so I don't know what happened. I don't know what happened.
When help arrives at their apartment in Winter Park, Florida, they find her boyfriend, Jorge Torres Jr., on the living room floor next to a large blue suitcase that served as his coffin. He had cuts and bruises on his eye and hands and some long scratches on his neck and shoulder, but after being trapped in the suitcase for 11 hours, he died from asphyxiation. Why was this man in a freaking suitcase? Well, Sarah told detectives they spent the evening drinking Chardonnay and putting together a puzzle, just a low-key, cozy kind of night. And then they had a better idea, hide and seek. One thing led to another, as it often does, and somehow Sarah ended up using a paper clip to close the suitcase with her boyfriend inside because the zipper was broken. Just, two people entertaining themselves with some wholesome shenanigans, nothing more, nothing less. They weren't even drunk, she said, despite the fact that they'd been drinking. Now, she claims she left him with 2 fingers free and thought he could get out on his own. So she went upstairs and fell asleep around 12:30 a.m. But when she woke up alone, she thought he was alive and well downstairs. When it finally occurred to her to check the suitcase hours later, it was far too late to save him. That was her story anyway. The detectives were skeptical. When they sat her down for a second interview and casually asked if she remembered taking any pictures or videos that night, she claimed she only remembered snapping a quick pic of her dog. But 2 videos from her phone told a very different story. From her seat
boy.
on the other side of the room, she pointed her camera toward the wobbling suitcase. Jorge is inside. He's struggling and he's calling her name, but there's no help coming from that direction. At one point, she can be heard slurring her words, saying, "For everything you've done to me, F you." The recording lasts for about 2 minutes, but this is a few unforgettable seconds of it. And a word of warning, it is disturbing.
I'm gonna keep that muted. I'm not gonna. Yeah, I'm gonna keep that muted.
His pleas got more panicked. Over and over, he told her he couldn't breathe. She said things like, "That's on you. That's what I feel like when you cheat on me." At one point, after he yelled her name, she could be heard saying, "You should probably shut the F up." In that first video, the suitcase is facing down. In the second video, police say it appears to be in a different position. And once again, he can be heard inside screaming her name as the bag wobbles back and forth. So, what did Sarah have to say about that? Well, she could only watch a portion of it before she told police to turn it off. She admitted it looked bad, but denied intentionally leaving him to die. She claimed to have no memory of making the recordings and blamed it on the booze. That was, if you remember, a little different than her original claim that they'd been drinking but stayed sober. But she insisted she didn't realize how dire the situation really was. According to the police records, she assumed his shouts were merely a case of a boy crying wolf. But if she didn't remember recording the video, how does she remember dismissing his pleas as like crying wolf?
Also true.
According to one Orange County deputy, Sarah was asked why she didn't let Jorge out when he asked to be let out. And she said, "Well, number one, I had no idea it was going to end like that. Number two, I'll give you 5 minutes or so in there."
What?
In the eyes of the police, this was looking less and less like an accident. And when they did a little digging into the couple's 3-year relationship, they uncovered a history of domestic violence between them. In 2018, they were both arrested and charged with battery after an alcohol-related altercation at their home. According to
That's not surprising. All right, back.
police records from the incident, Sarah said Jorge was angry because she was talking to another guy at the bar, so he dragged her upstairs and kicked her in the face.
Damn.
Jorge, however, claimed that Sarah was the assailant. In his version of the story, he walked upstairs to remove himself from the heated situation, only for her to wrap her hands around his throat and try to strangle him. Now, according to the affidavit, he told police he kicked her, but in self-defense. In the end, they were both arrested, charged, and subsequently released. But their relationship only seemed to get more toxic. In 2019, Jorge was charged with battery 3 different times, the most recent of which occurred in September of that year. According to the report for that incident, Sarah accused him of punching her in the ear. Now, a neighbor came forward to describe the sounds that he often heard coming from the couple's apartment. Loud music and louder fights were common, and he wasn't the only one to notice. Other neighbors had complained about the noise too. Sarah was arrested on February 25th, 2020, and charged with second-degree murder. If convicted, she faces a maximum sentence of life in prison. Oh, what do you think happened that night? Was this an innocent game gone wrong? Gone very wrong? Or do police have it right? Did she knowingly zip him up in a suitcase and leave him to die?
Okay. So, next one. So we're going to flash forward. So there's not a whole lot that gives you a more comprehensive of her case going thus far. But oh my God. This is from a month ago.
A Florida woman accused of murdering her boyfriend by leaving him to die inside a suitcase during a supposed game of hide and seek is once again voicing her frustration from inside a jail cell. Sarah Boone, the woman accused of murdering her boyfriend Jorge Torres by zipping him up in a suitcase where he suffocated to death, continues to demand access to evidence ahead of her high-profile trial. Ahead of Boone's trial, she has gone through several court-appointed lawyers who have all asked to remove themselves from her case, and lawyer number 8 is seemingly no different. On June 11th, Boone's attorney Patricia Cashman filed a motion to withdraw, citing irreconcilable differences. But about 4 days prior to Cashman filing that motion, Boone herself, in a move that she's no stranger to, would write a nearly 60-page letter to the judge expressing her frustration with Cashman. On page 1 of the 58-page letter, Boone wrote down several instances of her not getting access to documents and evidence. Some include, "Why can't I use my constitutional rights? Am I the only one who cares about the ongoing violations? Why can't I have bond? Why can't I have all my medical records? Why can't I have all my digital evidence and discovery? Why can't I have all my paperwork, notes, letters, pictures, everything of mine returned by former attorneys? Why can't I speak to my investigator? Why can't I have any of my witness list? Why can't I be treated fairly, lawfully, and be protected by the justice system?" Then Boone writes about her attorney, adding another list of instances where she seemingly believes her lawyer isn't doing enough. Boone writing, "Why can't my attorney give me an honest answer? Why can't my attorney show me everything she says she has and finished reviewing for my case, but withholds from me after I repeatedly ask for and about? Why can't my attorney grant me access to anything I ask her for in and about my case? Why can't my attorney, like the detectives in my case, stop putting words in my mouth? Why can't my attorney tell me what's going on in my case? It's been well over 100 days she has been my attorney, and I still don't know, ongoing 5 years." By page 5, Boone asked the judge, "I very much want to advance to the next level after ongoing 5 years now. A genuine concern limit has been reached. Why am I still not being included in my case? How much more of my care and self is being added hourly, especially after this letter gets loose to the internet, increasing the mass infliction and destruction of my homes to have a fair trial? Anything fair, my side foremost, and wondering how, if my attorney drank the punch like everyone else." Boone even admitted to walking out of meetings with her attorney due to what Boone called unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answers to her questions and beyond. I just want to thank Morgan & Morgan for sponsoring today's Law and Crime YouTube takeover. If you've seen our videos, you know Morgan & Morgan is a proud sponsor of Law and Crime, and our content proves the world isn't always safe. When you're hurt, it can be confusing and scary, especially if you don't know where to turn. Well, Morgan & Morgan, America's largest injury law firm, can help. They're the largest injury law firm because they win a lot. Morgan & Morgan recently received verdicts of $12.2 million in Florida, $26.2 million in Philly, and $6.8 million right here in New York. Also, there's a $0 upfront fee. You only pay them if you win. So if you've been injured in an accident, you can check out Morgan & Morgan. You can also submit a claim in 8 clicks or less without having to leave your couch. So you can start your claim at www.forthepeople.com/YouTube takeover. Later in the letter, Boone remains adamant she's not the problem, writing she should be treated fairly with respect and that she's been acting more.
So this is with her this is we're complaining about her 8th attorney, and she says that she's not the problem. I don't know about that. I kind of think like after the second replacement, I think it's a you issue.
Professional than the paid "I've been doing this for over 40 years" professional. As Boone has cycled through 7 lawyers since her case began, she wrote in the letter, "I have not fired any attorneys appointed in my case," adding, "Representing myself is not an option, as both judges have now threatened me with, from being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced." The letter then keeps taking a bizarre turn when she includes a glossary of legal definitions, including notice of discovery, prosecutor's discovery obligation, restricting disclosure, sanctions, then goes into the Declaration of Independence preamble, as well as the Florida Constitution. About 3/4 into the letter, Boone wrote about the public interest in her case with a map of the United States, as she made a star on each state where she's received a letter or a message about her case. The stars can be seen in Washington, California, Colorado, Idaho,
Dallas,
Arizona, South Dakota, Kansas, Texas, Missouri, Minnesota, Wisconsin, Georgia, Florida, and more. She writes the number grows daily as she adds, I, the defendant in my case, have not yet ongoing 5 years fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. Then writes, the continuations of the obvious exploitation allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. Boone's trial has been pushed back several times, in part due to the constant withdrawals of attorneys.
Judge, the letters that have been coming to Your Honor, the derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone, especially in a murder case.
And the previous judge overseeing her case previously said in court, Boone's attorneys might not be the problem.
But one thing I want to caution you about, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. You have a right to a court-appointed lawyer. There are certain decisions a defendant gets to make in the defense of their case that are absolutely theirs, such as whether they go to trial or not, such as whether they testify or not. But there are many decisions in a case that a lawyer gets to make. And while you certainly have a right to consult with your lawyer and discuss with your lawyer, they don't automatically just do whatever you say. They use their professional judgment and experience and look at the evidence, look at the law, and do the best they can.
But it'll be up to another judge to oversee Boone's case, as Judge Michael Kraynick has taken over the case from Judge Wayne Wooten, who Boone previously wrote a number of letters to in the past. Boone has been behind bars since her arrest in February of 2020, charged with the heinous death of her boyfriend Jorge Torres. He was found lifeless inside a suitcase at the couple's apartment. The gruesome death was captured on video taken by Boone herself, showing the chilling final moments of Torres's life as he cried to be freed from inside the suitcase.
Nope. We are not. We're not listening to that. Yeah. Bam. Oh, man, they are showing everything on Long Crime Network. Jeez. Moving on.
When they decided to play a game of hide and seek. Boone would later tell police once they responded to the scene, she assumed Torres would be able to get out. So instead, she went to bed, later finding him the next morning lifeless, still zipped up inside the suitcase.
I fell asleep, forgetting that he was in the
you guys
suitcase.
were playing the hide and go
Yes.
seek. And at some point you put him in the suitcase?
No, he got in the suitcase. So he thought it would be funny to be put in the suitcase. So I was like, okay, well, I'm going to joke with you and I'll zip you up and make him, squirm a little bit, whatever it is. But then I fell asleep. I fell asleep.
Where was the suitcase?
Right where
got
it
in
is.
it, right down there?
Yes.
You zipped him in there?
Yes.
Thought he would be funny, a little
It
joke.
was. We both were laughing about it.
Okay.
And then I fell asleep.
Where did
I
you fall?
swear we both were
Upstairs.
laughing.
In your bedroom?
Yes.
Okay.
Totally forgetting that he was in the suitcase still.
Totally forgot.
And then you came back downstairs?
This morning, or this
around
afternoon, yes, when I got
ballpark,
up.
what time?
12:30-ish. I was awake, but I totally forgot that he was in the suitcase.
But that alleged fatal mistake would end with Boone's boyfriend dead. During Boone's police interrogation, she denied zipping the suitcase entirely, despite video evidence showing investigators the opposite.
And you also, in the video, you can't see any holes. There's nowhere in that where the zipper separates and you can see a hole. If there's a hole, he's pushing on it, begging you to get out. We should probably see that hole. That
He
you're
essentially
talking
would have
about.
been able to get out.
Yeah.
Alcohol.
Based off what you're telling us, he should have been able to get out.
Okay.
But the video shows him attempting to get out, begging to get out, and he can't. So that's just what we're trying to figure out. I don't know if maybe you had too much to drink, you zipped it up all the way, and then,
I did not zip it up all the way. I did not zip it up all the way.
Oh, hey!
This is
Welcome,
horrific, okay?
Mike.
Horrific.
It is terrible.
Welcome, Mike and
Horrific.
company. Thank you, guys. Welcome.
I don't think I'll ever be right because of this. Ever be right. I didn't mean to leave him there. That's what I'm trying to tell you.
Welcome,
got up and
Raiders.
walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole knowing that it's there. He'll get out no problem. Because you don't.
And then he doesn't, but you don't go check on him. You say you're up for 30 minutes, and he doesn't come up. You don't go down and check on him?
I'm in the bed.
You even moved,
And
I
dozed
mean,
off.
you admit to moving the suitcase, like, over, so.
You roll it.
You roll it out, like, it's not like.
I didn't want him to be like that. Don't.
You didn't want him to be upside down? How do you even get upside down?
Right.
Oh, they're
They're
showing the
right
video. You can still
According
hear
to
the
an
audio a
autopsy
little
report,
bit.
The medical examiner noted multiple injuries to Torres's body. He had long nail scratches on his back and neck, contusions on his shoulder, skull, and forehead, considered as blunt force trauma. Boone was adamant to police she did not mean for Torres to die.
I promise you, on my son's life,
Oh,
it was
don't do
not
that.
intentional. I promise you, on Lucas's life, it was not intentional.
Stop
I don't
doing
know
that.
you. I can't say I know anything about you. I don't know what would be a true statement, what would not. I mean, you're promising on your son's life, that's fine.
That's how much it means.
Sorry.
That's how much it, look, that's how much it means.
Okay.
I hope you take that to heart.
Now, 4 years later and 7 attorneys later, Boone is still behind bars, with her trial now slated for October. In a stunning move, Sarah Boone forfeited her right to counsel. So now lawyer number 9 is going to be Sarah Boone herself, as the judge granted her former attorney's motion to withdraw. Boone's trial is slated still for October 7th of this year. Reporting for Law and Crime, I'm Elizabeth Milner.
Okay, so that was from a month ago, where she's now representing herself. We're not going to go through the whole hearing yesterday. But we're going to go through some of the more recaps. So that's what 23 hours ago. I think this is the better one to watch. Yeah.
You have 62 days to prepare for trial.
Wow. So in over 4 years, it comes down to me representing myself in 62 days?
I'm not going to answer that question.
Sarah Boone, the Florida woman accused of zipping her boyfriend up in a small suitcase and leaving him in there to suffocate, appeared in court Monday representing herself. This after a judge ruled that her repeated clashes with public defenders means now she's on her own. We've got the biggest updates from Boone's latest appearance and what the court recently granted her as she tries to navigate going pro se. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Sarah Boone may be making a name for herself as a difficult defendant. It's probably a kind way to say it. And what a day in court she just had, and we're going to get into that. But I got to give you some context on what's happening here. So, since her arrest in 2020 for the murder of her boyfriend, George Torres Jr., she has gone through 8 public defenders, 8 attorneys.
Honestly, it should not have gotten through. It should not have gotten past attorney number 2. It really shouldn't have. The fact that she's gotten 8 over a 4-year period is kind of ridiculous.
With several of them stepping away from her case due to, quote, irreconcilable differences. And Boone has made no secret of her feelings about her attorneys. In her correspondence with the court, she has called various attorneys snotty, duds, buffoons. One attorney wrote in his motion to withdraw that, quote, no attorney can satisfy her. In June, the latest, Patricia Cashman, who has been described by the court as being widely known to be able and willing to deal with and manage difficult clients, she asked to withdraw. So what did Sarah Boone do? Well, I got to tell you, this is a first for me. I don't think I've ever seen anything like this happen because she put her creative skills to the test and she drafted, I'm not kidding you, a help wanted ad If this story weren't so horrific, it would almost be comical. Because in this ad, she says the candidate to be her attorney, what a great job that will be, should have, quote, original creativity.
Oh my God, really? Zealous with a side of keen?
Extraordinary expertise and confident ingenuity. It reads, looking for a prosperous challenge? Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are. So far, no takers. Shocker, right? Shocker. Who, I can't imagine. Not everybody wants
Maybe
to jump on
Giuliani?
this case. Now, Boone, she is charged in the second-degree murder of George out in Winter Park, Florida. This is north of Orlando. And according to police, she and George had been dating for several years when Boone admitted that she intentionally zipped George into the suitcase, claiming they had been drinking and playing a game of hide and seek. She says she went to bed forgetting he was in there, found him the next morning. The problem with that for her? The investigation uncovered a cell phone video allegedly recorded by Boone that shows her seemingly taunting George in the suitcase as he begs for help.
Why do you keep playing the audio? Goodness.
Powerful piece of evidence for the jury. Now, during her interrogation, Boone told the detectives that George was an alcoholic, that he had been abusive towards her. They both had arrests on the record for domestic violence incidents, she claims. In fact, we looked up Sarah Boone and her legal history on truthfinder.com. That's our sponsor. It's one of the largest public records search services in the United States. And by the way, Truthfinder is so easy to use. You type in a name within minutes and a paid subscription purchase. You can access unlimited reports that can include information like phone numbers, location history, criminal and traffic records. Also, if you type in an address within a report, it shows you registered sex offenders in that area, which is just kind of wild to see. And you can
flash flood warning. Woo!
Use Truthfinder to research new dates, friends, maybe just reconnect with people. It's really a great tool. And right now, you can get 50% off of your first month of confidential background reports. Just go to truthfinder.com/LC Sidebar. But going back to Sarah Boone, Boone insisted that while she might have made a horrible mistake when it came to George, she didn't kill him on purpose.
Nobody knew George better than I did. I say that I knew George better than himself. And I tried in every way, shape, and form. Ask everyone. I helped him. I took care of him. I missed him a lot, and I didn't even sleep last night.
Well, I thought you did. I thought you said you did sleep last night.
I mean,
Oh
is
wait,
there any
this
chance
is
it got to be
this is
too
second
much for you?
interview.
You couldn't handle taking care of him and
I never stopped.
trying to.
I never stopped. That's what I'm here for. I never stopped. I'm here now because I'm still trying to help him.
But why is he saying I can't breathe, and why is he pushing on it as if he can't get out?
And it doesn't show a hole.
There's no hole. There's no fingers. I don't see his fingers. There's no hole.
I don't know what you want me to tell you. Like, I don't know.
By the way, since 2020, Boone
Well, are you believing me or your lying eyes?
has been locked up in jail, and despite being there for 4 years, Boone doesn't appear to have had a hearing on whether she can be let out on bond. She's previously suggested that even though she expects that the bond would be high, her, quote, fans would be willing to donate to the cause.
Fans?
So with all that, now let's talk about what happened on Monday, this hearing. So Judge Michael Kranick addressed 4 motions that Boone filed via mail, which we're also going to be able to take a look at. Now, in her loopy handwriting, the first set of correspondence with the court is titled, Motion Requesting Immediate Relief to the Defendant by Appointing Effective Standby Counsel to Aid and Support in Preparation for Her Criminal Case for Trial. Now, Boone names herself as a pro se indigent defendant, indigent meaning she can't pay for her own outside counsel. That's why the court had granted her public defenders. So she's representing herself pro se. Now, she goes on to list several legal precedents that grant her the right to standby counsel and says, quote, by the court rejecting professional, educated, experienced aid and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the
You do not have a constitutional right to standby counsel. Period. Some states offer it, or offer that that option, but you do not have a constitutional right to one.
Unfair disadvantage to press circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Wow, that's a mouthful. So on the one hand, she apparently hasn't liked or worked well with any of her public defenders, and remember there's 8 of them. But on the other hand, she wants to know why the court is forcing her to go pro se. While also present in court on Monday was a member of the Justice Administrative Commission, or JAC, Christian Lake, and he pointed out that standby counsel won't actually be there to help Boone along the way.
I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is asserted to represent themselves decides at some point they do no longer.
Yeah, so it's basically it's like the alternate jurors, or the alternate jurors in a criminal case. Like usually you'll have like a seat of 12 jurors, but then they'll have like 2 or 3 alternates that also sit on the trial. So in case 1 or 2 of the jurors, for whatever reason, has to absolve themselves of the hearing, though one of those alternates can come in and be able to sit on the case without losing any steam. So standby counsel is just there to sit, watch the proceedings, and so that they're able to be on the up and up in case she decides, you know what, I think I'll let counsel handle this from here on out. No, they're not there. The standby counsel is not her personal paralegal.
Want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is incenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State 152 Southern 3rd 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State 449 Southern 2nd 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard v. State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
My dog Clover, thank you for becoming a member.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I do not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place.
Okay. Now okay, this is delayed. This is obviously a delay tactic. Her acting this way is obviously a delay tactic, which is odd because all she's doing is she's in prison, so it's not like she's able to hang out outside in the outside world. But yeah, this is the delay tactic.
And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
The judge let Sarah Boone know that this trial is scheduled to begin October 7th and that the court will be extending the time frame for trial from 2 weeks to 3 weeks. It seems that Boone will have a chance to review the evidence that the state wants to admit next month, but the defendant took issue with how quickly things would be moving and how much time she would have to prepare.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
He's not gonna answer her question. He's gonna say you have been informed of the respective deadlines leading up to and on trial.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today, and you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
That sounds like a you problem. It's your fault.
I'm not going to answer that question.
Yeah.
Am I supposed to?
What now we're addressing, ma'am, is September 17th.
Right.
The deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you.
Well, so that's a you problem. You've abused your right to counsel. And so you've therefore absconded your right by having yourself replacing your court-appointed attorney 8 times. Now you got to figure it out.
That would be me providing you legal advice.
Exactly.
I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th.
I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date.
Yes. Yes. You as a defendant, you can lose your right to counsel. If you're abusing that right. It's the bar has to be set very, very high because it is an explicit Sixth Amendment right to legal counsel that you have, well, in criminal trials where your liberty is at stake, and you cannot afford one if you're indigent. So those are the 3 caveats there. But either way, you have that constitutional right. So to take away that right, meaning like you are abusing the process, you can no longer you are now representing yourself. The same way as the court can take away your right to represent yourself as well. They're both constitutionally protected rights, but they can be taken away if the actions are egregious enough.
And then not be able to meet it. What happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Well, she admits that she doesn't know what she's doing. Now, the judge said repeatedly during the hearing that the reasons why Boone forfeited her right to counsel, they were laid out in a document already filed, and that was sent to her. That 16-page order lays out all the problems that Boone has had with her attorneys and all the times those public defenders have asked to withdraw from the case. And he then cited precedent for why a defendant might have to go pro se. Well, in her letter, Sarah Boone talked about her rights. And for example, she writes, quote, waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused it. It is made by a person with full capacity, unprepared, that is knowing, involuntary, forced, and that clearly and unequivocally rejects representation of assistance.
Yes, but your conduct can evidence your forfeiture of that right. And your constant delays and your constant demands for a new attorney, we're at 8 now, that I think that I'm very confident the judge is safe on appeal that you, by your conduct, have forfeited your right to counsel. And so they don't need you to explicitly state that you were making a knowing involuntary waiver.
By an attorney at law during the pending proceedings. And Boone is continually saying that she was forced by the court to represent herself. But here's the problem. Here's a little legal primer here. Yes, criminal defendants have a right to counsel. It is in the 6th Amendment. It says that
I'm pretty sure Jesse's going to say the same thing that I just said. Castro, thank you for the $5.
In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. But in terms of a right to counsel, while a defendant can certainly have a choice at times on who he or she wants to represent them, this is not an absolute right. If the defendant engages in misconduct, they can forfeit that right to counsel. You can't engage in conduct, for example, that deliberately delays the trial or obstructs the proceedings. And here, this is what has happened. Boone has forfeited her right to counsel. The judge has written, quote, forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. The judge continued, it has become apparent to the court the defendant will not permit herself to be represented by anyone. Now, another issue that the court addressed is how Boone can represent herself when she's currently incarcerated and may not have access to everything she needs. In her letter, she points out that she, quote, does not have access to a computer and does not have access to the internet. Defendant does not have access to organization supplies or production equipment. Then in parentheses, it says copier, printer, etc. Defendant does not have access to a meeting place for privacy and case review preparation. Boone even listed examples of some of the hardships she's facing. First, the defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24. Boone has contended that she didn't even know her last court hearing was happening and was unexpectedly dragged to the courthouse. So that means, of course, she also hasn't had a chance to review that discovery. She reiterated these concerns to Judge Kranick, and let's see how that went.
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research.
You're in jail. You're not going to have regular access to a phone. Of course not. I don't know what jail she's staying in. I'm assuming she's in a jail, not a prison. I assume that a jail probably has like a library for inmates, and I'm pretty sure like it's fairly standard that most of these facilities do have limited access to the internet, computers, and copiers. But she's she doesn't have unfettered access. She's not entitled to unfettered access to all of that.
Research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I would be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to-be-determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
All right, I just want to highlight some other interesting tidbits from Sarah Boone's correspondence with the court, because in another letter, she makes out all these other requests. For example, it says, comes now Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire investigator for defense's defense in trial. She writes out investigator, TBD, meaning to be determined. Total amount requesting, TBD. How to calculate, unknown by defendant. Reason, no discovery or case materials provided to defendant from the judge. And she reiterates a lot of what she said in the first correspondence to the court, mainly that she's been forced to represent herself and that the court is hiding information from her. Boone also requests money to pay for expert witnesses, saying that once again the costs are to be determined. She filed another motion requesting reservation of any and all costs proposed to be incurred to acquire all witnesses needed for the defendant's defense in trial of her criminal case. She also wants to be able to depose witnesses. So what was the response to all these requests? Well, the Justice Administrative Commission filed a response, and it said, quote, as for costs to take deposition, the defendant is authorized to incur costs to take depositions for those deposition authorized under the Florida Rules of Criminal Procedures. As for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. The sheriff must be used to serve in-county law enforcement. The document goes on to say that private investigators cannot be paid more than the rate of $50 per hour and that they have to be licensed in Florida. Well, what about witnesses to testify in Boone's defense? The response says, based on JAC's records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. JAC does not object to the court continuing this authorization now that the defendant is representing herself. As to other requests for other experts, the defendant will need to file an appropriate motion delineating the following. 1. Identify or type of expert. 2. Amount authorized cap for the expert services. And 3. Rates authorized for the expert services. As for just regular witnesses, the commission says Boone would need to submit a more detailed motion about why there would be costs associated with each of them. This is why you have an attorney represent you. This is why it gets complicated. Very simple. Yeah. Okay? Well, for now, Boone's trial is scheduled to begin in October, and Judge Kraynick has said, he's indicated, that this trial will not be delayed any further unless there is extraordinary good cause to do so. And that doesn't mean if Sarah Boone decides to retain new counsel. This trial will move forward at the same pace. Later this week, a hearing is scheduled to determine if Sarah Boone will be allowed to be unshackled during trial. We will see what happens, and we will continue to follow this case for you right here on Sidebar. That's all we have for you right now.
So this is in the actual hearing, the actual footage of the hearing, and I want to see if I could find certain moments in it. We're not going to go through all of it. It's an hour 44.
2020 CF 2603, the state of Florida versus Sarah Boone, state.
Dave Castron, behalf of the state.
Ms. Boone, raise your right hand to be sworn, please.
Relate with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them. and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed cause to acquire investigator for defendant's defense and trial dated July 18, 2024. Of proposed cause to acquire attorney title. All three motions reflect to be determined or TBD. With regards to
just
those,
talked about that.
Copy or to send your JA a copy. No, Your Honor, again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific.
Constitutional right to stand by counsel as decided by.
In my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to having an understanding before you take someone's right to it.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And
perjury?
Reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to...
The chutzpah of this lady.
Visit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion. All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case management.
There we go.
And then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay.
No, she's not, Nimrod.
What are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything?
That is correct.
I'm clear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this.
Nimrod, take me to 20 months.
I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So
Oh my God. Yeah, sure. Yeah, we'll just give you all the privacy you want when reviewing the state's evidence.
I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go with answers.
I'm certainly giving you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
And just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So
yeah.
attorneys don't get privacy when they're reviewing the physical evidence.
Exactly. Yeah, that like attorneys aren't allowed to do that
either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence.
Yes.
So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
because you're in custody. There's no evidence that she was trying to tamper with evidence, but her complaining about wanting to have some level of privacy when reviewing the state's physical evidence raises a lot of red flags.
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term, and then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding.
Usually, I would say that usually the media would not be permitted to participate in an evidence viewing. I feel like that would generally not be permitted.
There are rights where the media has to view proceedings in court.
Yes, that's true.
Due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent
Carl B, thank you for the 5 gift memberships.
Media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised.
No. I think evidentiary hearings can be televised, usually for like evidence viewing.
So, if you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The 1st is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, the USB drive or the, after our viewing meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County
Bad
Jail,
Hatter,
there
think
are
of the 21
classrooms,
months.
or at least one classroom there, need to be there. It would be recorded and the evidence against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use.
Yeah, probably not.
There's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail?
So this is for the digital evidence, aka the infamous videos.
Under the concept is
autopsy photographs, etc.
So this meeting is separate. This is prior, before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion, if there is a discussion to be had about plea offers. One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of the discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, okay, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how.
So I'm trying to find a particular moment that somebody mentioned to me that I wanted to hear. That's why I'm kind of skipping through this, but it does have to do with digital evidence.
The USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much prefer...
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if it is a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are, so I don't know what it is different, and I don't know.
And I read it to you at the last hearing.
Your understanding is different than my understanding, because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved for fear of harassment or anything.
Oh my God.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by notice of service.
I have yet to receive anything such as...
Don't worry, I have a copy out last week.
I have yet to receive anything such as...
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process?
It was served by U.S. mail.
By U.S. mail? Yes. I actually have 3 motions, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error and all for the USB drive in the jail, or to the USB drives. Put on a USB drive, identifying when he received it from the state to
the jail.
For the purpose of use.
Contact someone at the jail.
No, ma'am. That's going to be provided to 4 people.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or be postponed, or if it's something in jail. So a feat in itself. So in the process of withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing.
Feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Service withholding my evidence in any way, shape, or form.
So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
Can caveat in that order be, unless it hasn't already been done? In case we do it ahead of September?
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th, and if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. so that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Yeah.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself, to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get that.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that, and like I said, Mr. J, if you could follow that notice, just
The laptop is closed for the day at 4 p.m. I can therefore pick up using a hard copy of it.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
Yeah.
In regards to taking my counsel and all of your words.
You are.
Whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. Already printed out of the protocol. We will have the deputy hand deliver that to you after you've reviewed the physical evidence to provide your exhibit lists.
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other...
Oh, she's still complaining about that.
Fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good cause is now, if not there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr. Lane.
Okay, all right. I will set a deadline for the review of September 26th.
Is the review that you're speaking of, please, for my exhibit and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. Any objections, anything else from the state that you believe we need to address from a scheduling concept?
Come on, where is it?
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made note to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay at the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Sergeant Thomas Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown court holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Can you raise your right hand? Madam Clerk's going to swear you.
So I believe these individuals are going to be the sergeants that are going to have that going to be in charge of the USB drive that contains all of the or most, if not all of the digital evidence on file for the defendant. I believe this is for the chain of custody maintenance.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 bankers' boxes of information, and you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers' boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you had previously by virtue of being the investigator.
Yes, sir.
Okay, all right, the record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, you can please take custody of those 2 thumb drives.
Chain of custody.
And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for me, Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocol as provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved?
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 bankers' boxes. Did you bring those back with you, sir?
Yes, sir.
Okay, could you bring those back up? I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm going to have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Thank you.
Thank you, sir. I appreciate you.
One housekeeping thing.
Yes, sir.
I don't know if Mr. Lake, since he's here, would like me to sign my invoice or have Ms. Boone do it since she's pro se.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah.
Regarding your use of the laptop at the jail,
Uh-oh,
I'm
under.
going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you, it was read to you at the last hearing, but now you have a...
Address that today, unless they're allowed.
All right, what's this? I think he's reviewing her motions.
Delivered motions. It is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, hyphen A, comma B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, Counselor, and just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the Sheriff's Office, who is in charge of courtroom security, so we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, I appreciate that, sir. Ma'am, with regard to your request for discovery, the hard copy discovery, you've advised me multiple times seeking to use a laptop. I have written correspondence from you asking for a laptop.
Yeah.
That laptop is...
Why do you want the hard copy now?
At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain, to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never...
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through the correspondence. But when we have our hearing on the issue of the your motion for freedom of movement, where I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited, restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time we met with one another. So I'm confused how everyone is complex and you're coming to the wrong conclusion. I'm
not coming to any conclusion. The process was created, and I'm just reciting what you've said to me. You have no private locker or access to. For conclusions, there's no nefarious addressed at the last hearing. I could not copy it. I can't look at it. To take both those bankers boxes, me, as identified in that protocol, as to how and when, and that was the process of getting this information to you.
Letters to you prior to you forfeiting my right to counsel, I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
You never asked me in regards to the hard copy.
Hang on, yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So, if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern as, Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver, and I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 bankers boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
Actually, I'm just trying to find a solution. So if she moves or tennis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th we can revisit this when the captain's back.
I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so Mr.
I'm just pleased to get them to
like the court to
Propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, you can release them to me.
Granted.
No objection to
No, they're not behind me.
Mr. Lane, thank you for staying, sir. I appreciate you. If you have Ms. Barrios coordinate, cannot do it the 13th. Hard copy. I inquired of you as to when you might be able to go visit her. You said the jail would bail.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those 2 boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been tossed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available?
Friday.
On Friday. Orange County's motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, yes, please, one moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That's deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided, the names of the persons at the jail regarding the laptop protocol is Captain Giovanson, Courtney Battle, and put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, represent yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence that I might be able to utilize that?
She wants access to her phone. This is what I was waiting for. She wants access to her phone that was used in the murder.
So my understanding is there was an imaging done on your phone with software called Cellbrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person who hired. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R, and then that will be between you and the KAC and him, whether or not he wishes to work for you and at what rate, and so on and so forth. And then that examination would be done by him, with us being present if we want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a mirror download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list under the mayor if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself.
No.
Before trying to figure out how to locate and contact an expert to download all of that to receive.
Nimrod, take me to $5.99.
All that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. But there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence, because like you said, there's so so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in two different fashions. One is a large PDF, typically hundreds of thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader, and then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that is taken care of.
Just as clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior, so this would be a milestone, an epic milestone for you to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about, I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy mirror download of my phone. If it could be brought to you for physical, with the other physical.
So again, that's going to be something that requires an expert. And then if you get a defense expert, the jail.
Yeah, sorry, like.
Case your phone just as we did, and you all can work with that image. If you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, we're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you all are supplying?
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to, is the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence and me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
She really wants access to her phone.
It needs to be a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of its phone. Of the phone.
Thank you very much.
Ma'am, do you have any other questions?
All right, that was all. That's all I wanted, because yeah, I was told that she really wants access to her physical phone. Oh, that's funny. All right, I'm probably gonna have to log off now. The thunder is rolling in, and even though I do have my PC on a power supply, and a surge protector, you never know. But all right, hi. No, don't go away. Come here. So, for those of you who are asking about updates, he's eating. He was eating a bit more this morning, but not too much. The doctor suggested that I only give him reduce his medication, and they prescribed me an appetite stimulant. It's like this little ointment that goes into his ears or whatever. So he did eat a little bit, but not too much. So hopefully I'll probably give him a little bit more of the stimulant. Assuming I can just use it one or 2 days, and it'll kick back up. He's at least drinking water, so that's good. But the doctor said I should be getting the results of his blood test tomorrow, and the doctor said I should start giving him back his regular dosage in a couple of days. So that's what he's doing. We're But overall, otherwise he's doing well. His heart is doing well. So there's no issues there. It's just that want to get him back to eating. I think the medication could be giving him, nausea. So that's why he's hasn't been very hungry. All right. All right, guys. I appreciate you guys. You know what? The fact that he's hanging around here probably hints that he actually is hungry again. So I guess that's a good thing, actually. Winston, he's about 13 now, actually. I just realized. He's at no, not 13. 12. He's 12. My bad. All right, guys. You have a good night. Take care. I'm gonna go see if he wants some more food, and I'll see you guys next time. Okay? Adios. Take care. Bye bye. He's an old man kitty, but he's got a permanent baby face. I always feel like he's still like 6 years old. All right. Bye, guys.